Angeles jury found Meta and Google negligent for designing social media platforms that are harmful to young users. Joining us now is Jeremy Rosenthal, trial attorney and founding partner of Rosenthal, Kalabis, and Therian. Jeremy, good afternoon. Thank you for joining us today. So to start off, I just want to get your thoughts on this. Do you think the results of this case could be a potential bellwether, if you will, amid social media addiction lawsuits against big tech? How significant was this ruling?
It's pretty significant, and I think the answer to your question is yes and no. First off, this lawsuit relied on California law specifically, and it was able to navigate some of the federal restrictions that have historically protected Meta and other social platform users. And such social platform companies. So think of it like this. There's the First Amendment to the United States Constitution, which prohibits the government or a court from coming in and really regulating what is said and content that's like that. And if you're going to award money to somebody who was their mental health was damaged as a result of your product, well, you're essentially, that's what you potentially run afoul of is the First Amendment. Also, there's Section 230 of the Communications Act, which also says that as a social media platform, you're not liable for things that other people post on your platform. Where this is a little bit different was that the plaintiffs in this case were able to sort of get around some of those hurdles in the state of California because of California law. So I think if you're Meta and you're Google and you're any other social platform company, I think you're sort of hoping that the damage is limited to maybe California or things like that. On the downside, certainly the plaintiffs in this case gave everybody a roadmap. I think all of us are sort of thinking that this is kind of a big tobacco moment, right? Where essentially tobacco companies had to start forking out and paying out a lot of money for this type of liability. So I don't know that there's a clear-cut answer, but this was certainly a good day for these plaintiffs in California.
Okay, so Jeremy, a number of things I'd like to follow up on of what you said just now. I'll start with Section 230. You know, as you're aware, often companies cite Section 230 that it's not liable for user content, right? So tell us a bit more how, in this case, the plaintiffs sort of sidestepped that. How was it successful to get around it, and why did it work?
Essentially, what the plaintiffs were arguing was that it wasn't the content that was the issue, it's the algorithm that's the issue. And not only that, but some of the algorithms that were used or some of the things that were used were misused not only under California law, but also by these platforms' own guidelines. Things like never-ending roles, never-ending scrolling mechanisms, the specific algorithms sort of engineered to kind of psychologically addict you. And not only that, you know, you've in the context of tobacco, right? You had tobacco knowingly running red lights when it came to engineering their product to biologically addict you. So I think that the argument here around Section 230 was really comparable, which is this is not this is not a content case. We're not talking about the content. This is a product's liability case. That's essentially how the plaintiffs argued it.
So to your point that this could be a tobacco moment, in the cases against tobacco companies over the years, what happened was that now tobacco companies have to issue warnings, right? So if you're saying this is a potentially tobacco moment, do big tech companies have to warn young users of the potential risks?
I would think that would be, at a minimum, really part of it. What you're really afraid of, if you're big tech, are the floodgates opening up and people bringing these lawsuits really all over the country, all over the state of California, and then having to shell out millions, if not billions of dollars in these types of judgments. And that's if you're a plaintiff lawyer or you're a class action lawyer, that's exactly what you're eyeballing right now. Is you're saying, okay, look, let's recruit everybody that can make a claim that their mental health was damaged because of some of these platforms, and then let's go and get a really, really, really big judgment. That is what would really potentially shape if you will, how these companies, how their conduct is going forward, whether they're going to follow their own regulations or their own guidelines or state regulations. So I think your major fear, if you are these big companies, is getting your pantsuit off here.
Okay, you brought up mental health issues, and that was part of the defense by the social media companies. So let me just get your comments on that. These companies saying that their platforms aren't intentionally harmful, and teens' mental health is complex, right? Tied to external factors like home, and specific to this case was the plaintiff's COVID isolation and other factors. So what are your comments on this?
I think if that's how I think that's how you would defend these cases, right? If you're Meta or if you're YouTube, you defend them by saying, listen, first off, where's mom and dad in all this, right? When does personal responsibility become our job and not mom and dad's job, right? We're not raising your kids. That's your job. That's certainly part of it. Also, yes, how can you pin us for mental health issues with this one child where yes, they were isolated because of COVID, where being a teenager is hard, where there's physiological and biological things that can certainly impact mental health. It's very hard to isolate the injury, if you will. It's very hard to isolate it and pin it on one issue and one issue alone. It tells you that this jury was probably very angry.
Okay, just a couple more things that I'm wondering here, Jeremy. And one of them is there anything to be said about what appears to be, relatively small damages of about $6 million between Google and Meta, which those two companies, I mean, they're massive companies.
Right, they could sneeze and lose that much money in the sofa in the front lobby, right? So yeah, that's definitely, I think, part of some of the debate. But I think you're sort of really curious as to how these plaintiffs were able to sort of navigate around and swim through all of the sharks in the water, if you will, that normally sort of snatch them up. This would be, in sports terms, this would be like the U.S. national team surrendering a goal to a little league team. How did it happen? And do we need to worry about what other problems do we have around here if that's what's going on here, right? So I think you're a lot more alarmed by the legal precedent that it's set than you are, obviously, the $6 million. $6 million is money to me and a lot of money to you, but like we were talking, they could lose that in the back of a taxi cab on the way to the airport. That's not a big deal to them at all.
Right. Okay, just one last thing, Jeremy. Google and Meta, they plan to appeal, right? So what is your feeling about this case, the strength of this case when it comes to surviving scrutiny in higher courts?
Well, it's certainly going to be an issue. And look, you've got the First Amendment, which essentially what, if you're the plaintiff, you want to do is you want to sort of take it out of the content regulation. That's why they characterize it, if you will, as a products case, essentially, because when you sort of characterize it as a products case, it really lowers it. And when you're talking about the algorithm, you're essentially saying, well, look, we're not targeting the content. We're not telling you what you can show kids and can't show kids, obviously within bounds. What we're talking about is how you feed it to them. How is it that the child gets a notification on their phone, a push notification? The intent is to check it for 8 seconds, yet the child spends 20 minutes on the phone. Those are the mechanisms, right? The psychological things that I think the plaintiff is pushing. And the question is, under First Amendment scrutiny, where does that really fall, right? Are we regulating content by regulating the algorithm? And if so, where's the boundary, right, between the product liability, between the product being at fault, and we don't like the content that you're reading? It's certainly a very complicated question.
Well, all right, Jeremy, let's leave it there, but terrific analysis today. Thank you so much.
Have a great day.
Judge Alvin Hellerstein today strongly advocating former Venezuelan leader Nicolas Maduro and his wife's right to counsel. The Maduros were back in court today requesting a dismissal of